The 25th Amendment to the United States Constitution deals with presidential succession and disability. It clarifies that the vice president becomes president if the president dies, resigns, or is removed from office, and establishes how a vacancy in the office of the vice president can be filled. It also provides for the temporary transfer of the president's powers and duties to the vice president, either on the initiative of the president alone or on the initiative of the vice president together with a majority of the president's cabinet. In either case, the vice president becomes acting president until the presidential powers and duties are returned to the president. The amendment was submitted to the states on July 6, 1965, by the 89th Congress and was adopted on February 10, 1967, the day that the requisite number of states had ratified it. Section 1 clarifies that in the enumerated situations the vice president becomes president, instead of merely assuming the powers and duties of the presidency as acting president. It operates automatically, without needing to be explicitly invoked. 108 Section 2 provides a mechanism for filling a vacancy in the vice presidency. Before the 25th Amendment, a vice presidential vacancy continued until a new vice president took office at the start of the next presidential term. The vice presidency had become vacant several times due to death, resignation, or succession to the presidency, and these vacancies had often lasted several years. Section 3 allows for the voluntary transfer of presidential authority to the vice president by the president declaring in writing to be unable to discharge the powers and duties of the presidency. The vice president then assumes those powers and duties as acting president. The vice president does not become president and the president remains in office. Although without authority, the president regains those powers and duties upon declaring, in writing, to be again able to discharge them. 112(3) Section 4 addresses the case of a president who is unable to discharge the powers and duties of the presidency but cannot, or does not, execute the voluntary declaration contemplated by Section 3. 117 It allows the vice president, together with a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, to issue a written declaration that the president is unable to discharge his duties. Immediately upon such a declaration being sent to Congress, the vice president becomes acting president while the president remains in office, albeit temporarily divested of authority. John Feerick, the principal drafter of the amendment, XII, XX 5 writes that Congress deliberately left the terms unable and inability undefined, since cases of inability could take various forms not neatly fitting into definition. The debates surrounding the 25th Amendment indicate that are intended to cover all cases in which some condition or circumstance prevents the president from discharging his powers and duties. Quote, 112 A survey of scholarship on the amendment found no specific threshold, medical or otherwise, for the inability contemplated in Section 4. The framers specifically rejected any definition of the term, prioritizing flexibility. Those implementing Section 4 should focus on whether, in an objective sense taking all of the circumstances into account, the president is unable to discharge the powers and duties of the office. The amendment does not require that any particular type or amount of evidence be submitted to determine that the president is unable to perform his duties. While the framers did imagine that medical evidence would be helpful to the determination of whether the president is unable, neither medical expertise nor diagnosis is required for a determination of inability. To be sure, foremost in was a physical or mental impairment. But the text of Section 4 sets forth a flexible standard intentionally designed to apply to a wide variety of unforeseen emergencies. 7.20 Among potential examples of such unforeseen emergencies, legal scholars have listed kidnapping of the president and political emergencies, such as impeachment. Traits such as unpopularity, incompetence, impeachable conduct, poor judgment, or laziness might not in and of themselves constitute inability. But should such traits rise to a level where they prevented the president from carrying out his or her constitutional duties, they still might constitute an inability, even in the absence of a formal medical diagnosis. In addition, a president who already manifested disabling traits at the time he or she was elected is not thereby immunized from a declaration of inability. 21 N63, 22 N67. The principal officers of the executive departments are the 15 cabinet members enumerated in the United States Code at 5 U.S.C. Section 101. Acting secretaries can participate in issuing the declaration,